We will go on the record in the matters 24 CF 170, 24 CT 33. State of Wisconsin versus Jacob Jones. The state appears through Assistant District Attorney Holly Rockow in person. We have Mr. Jones in person in custody with counsel Gabriel Pollock. We're set here today in these matters for two things.
Right out of the gate, we've got a legal curveball, an OWI-3 that was inadvertently dismissed. Translation, somebody oopsed, and now the court has to clean up the mess. Pay attention here. This is where procedure collides with paperwork, and the stakes get real.
First is with regards to 24 CT 33, the OWI third was inadvertently dismissed and read in with the agreement, and I do not believe that was part of the agreement. Is that correct, Mr. Pollock?
Your Honor, I guess I'd spoken to Ms. Rockow earlier this morning, and we had just noted that it had been read in and believed we were here for sentencing in the 24 CF 170 matter.
No.
Understood, Your Honor. I can certainly conference with Ms. Rockow to see how she would like to proceed with that. I guess I'm not sure how the court would prefer to proceed.
Because the OWI third was not a part of the agreement to be dismissed and read in particular because the legislature, as well as the public and the public interest, looks at those matters, the OWIs, very, very seriously. And
notice how the judge is laser focused on public interest. In Wisconsin, OWs aren't just bad decisions, they're political landmines. This isn't just about one defendant, it's about sending a message to the entire community.
That was overlooked by all parties, including the court, when all the multiple cases and multiple things were put on during the plea hearing. So with regards to 24 CT 33, that matter, the court does not allow that matter to be dismissed and read in. And if that affects today and what's going to happen today, then we need to address that, and this matter needs to be reset because, again, the OWI third in 24 CT 33 was not a part of the agreement that was reached between the parties. And that was not the agreement that was recited to the court. If that was recited to the court would not have permitted the agreement and would have proceeded to trial.
Understood, Your Honor. I believe that Ms. Rockow and I can likely come to an arrangement. I just had not done that at the moment, but I think we can likely have that figured out.
All right. So why don't you go conference with Ms. Rockow, and then you're going to need to conference with Mr. Jones because I don't want him to feel rushed, but this matter can all be reset to a different date and time. However, I do understand that this is your last day on the public defender's office in this capacity, and another public defender would need to be retained or appointed.
Yes, Your Honor, I appreciate that. I also know that there are numerous people here in support of Mr. Jones, so if we can accommodate this, that would be my preference.
All right, we will briefly adjourn.
Your Honor, I have completed the plea questionnaire, if I may approach.
Back on the record, same appearances as previously noted. The parties have reached an agreement. Mr. Pollock has went over a plea questionnaire waiver of rights form as it relates to 24 CT 33, operating a motor vehicle while intoxicated. Mr. Pollock, can you please recite the agreement on the record after the court is making the formal order to reopen 24 CT 33, because that was not a part of the original, that was not a part of the agreement, correct, Ms. Rockow? Correct. And correct, Mr. Pollock?
Yes, Your Honor.
All right, please recite the agreement for the record.
Your Honor, our understanding of the agreement, if Mr. Jones enters
So slowly.
Yes, Your Honor. Our understanding of the agreement is if Mr. Jones enters a plea of guilty to count 1 in 24 CT 33, which I believe is the operating while under the influence of an intoxicant, count 2 and 3 would be dismissed count 3 would be dismissed and read in, count 2 would be dismissed by operation of law, or Nope, count two is not operating while revoked. I thought there was a prohibited alcohol
Count
concentration.
4.
So the remaining counts would be dismissed and read in, one as a matter of law. The parties would join in recommending a sentence of 45 days in the county jail, a fine including the various surcharges of $1,844, loss of operating privileges, and requirement for an ignition interlock device for 24 months.
Where are you coming up with those things? You're just kind of pulling them out of the air?
Your Honor, I think a lot of this was the
Oh, did you catch that? The judge just called out the defense for pulling sentencing numbers out of the air. Judges hate fuzzy math. This is a reminder. If you're walking into court, you'd better bring receipts. In the right statute book.
That's not even my IDIP guidelines, which is the lowest, and that's not even the district guidelines.
Your Honor, I guess
Your Honor, I think that we're now viewing these as this is now kind of a global situation that we have here. We're resolving the felony file and the CT file together. The 45 days is the statutory minimum period. I think that's appropriate given the recommendations the parties will be making for the felony. We are recommending a lengthy period of supervision. So I think that's appropriate given that level of protection to the public. Also, I understand that Mr. Jones spent 12 months in the county jail or was sentenced to 12 months in the county jail due to the revocation. So I think that we can also factor that in terms of what's best for the public. The other thing is that there was an IDIP recommendation or offer that was made, of course. He had begun doing that process, as I understand it, according to my file at least. And then, of course, he was incarcerated. We're coming up with the 45 days because that's the statutory minimum.
Okay, what about the 1844, the 1,844? That's just a random number.
That's the 10th District guidelines for this offense date from the 2023 grid.
But this occurred in July 2024. My July 2024 grid is 1869.
the OWI was February of 2024. I don't think that the guidelines had gone into effect at that point.
You're right. I was looking at the burglary.
Correct.
That is correct.
So the state has no objection to the minimum fine.
All right. Okay. Now we're making sense. All right. Okay. So that's the agreement that's been reached, Mr. Jones.
Yes, Your Honor.
And I have in front of me the plea questionnaire waiver of rights form as well as the jury instructions. Did your attorney go over this with you?
Yes, Your Honor.
Did he go over it thoroughly with you?
Yes, Your Honor.
Essentially word for word?
Yes, Your Honor.
And you understand everything contained on these documents?
Yes, Your Honor.
And is that your signature on the second page of the plea questionnaire?
Yes, it is.
Do you understand that you're pleading guilty to an OWI third offense?
Yes, I do.
You're 24 years old. You have 12 years of schooling. You can read, write, and you understand the English language.
Yes.
You are receiving treatment for a mental illness or disorder, and you are taking medications. What is that mental illness or disorder?
Anxiety and depression.
And are you taking medications for those two particular disorders?
Yes.
And what are the medications?
Sertraline.
And you take that as prescribed?
Yes.
Does that interfere with your ability to comprehend or understand what's going on?
No, Your Honor.
Does it actually help you a little bit better?
Yes.
Okay. Now, other than that, no alcohol, medications, or drugs?
No.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on the plea questionnaire. Did your attorney thoroughly go over those rights with you?
Yes, he did.
So you understand those rights completely?
Yes.
Do you understand that by pleading guilty, you would be waiving and giving up those rights?
Yes, Your Honor.
Do I need to go over those rights with you in any more detail?
No, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you also understand that there is a recommendation for the court to follow the lowest guidelines as it relates to the jail and the lowest monetary guidelines for the lowest jail, the mandatory minimum jail for the jail time, as well as for the court to follow the district guidelines for the fines and penalties. Do you understand that I wouldn't be bound to follow that recommendation?
Yes.
And do you understand here, the state would have to prove on or around February 18th, 2024, that while operating a motor vehicle on a highway or roadway of this county and state, that you were under the influence of an intoxicant, and this would be counted as your third offense. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of less than $600, but no more than $2,000, or you can be imprisoned for not less than 45 days, but no more than 1 year in the county jail?
Yes, Your Honor.
And again, do you understand that I'm not bound to follow the recommendations? I could sentence you all the way up to the maximum possible penalties if I thought it was warranted.
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, I do.
Now, did you go over the criminal complaint, that original charging document with your attorney, which pretty much says what happened that day and why you were charged with the crimes?
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Are you admitting here today that you in fact did operate a motor vehicle while under the influence of an...
And there it is, the guilty plea. This moment is like crossing the point of no return in a courtroom drama. Everything before this was negotiation. Everything after this is consequences.
Intoxicant?
Yes, Your Honor.
Mr. Pollack, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
No, Your Honor.
You're doing so freely and intelligently, telling the court that you fully understand what you're doing here today,
Yes, I am.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes, he has.
Has he looked at this matter thoroughly?
Yes, he has.
Has he discussed with you a possibility of any defenses you could have if this matter would go to trial?
Yes, he has.
And has he discussed a possible lack of defenses you could have?
Yes, Your Honor.
And so you're satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
No, Your Honor.
As to count one, operating a motor vehicle while under the influence, a third offense, how do you wish to plead?
Guilty, Your Honor.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up the rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1 in 24 CT 33. Count 2 and 3 will be dismissed and read in for purposes of sentencing. Count 4 will be dismissed and merged in with count 1. A judgment of conviction will be entered today. Now we're going to move on to sentencing, and we will in fact do a dual sentencing in this matter. We have the sentencing for the operating while intoxicated third offense, and we do have the sentencing in the 24 CF 170 matter, in which you did plead guilty to 1 count of strangulation, suffocation, 1 count of false imprisonment, and 1 count of stalking. They are all felonies. The court ordered a pre-sentence investigation report. The court has reviewed that report thoroughly. I have also received and reviewed the sentencing memorandum for Jacob Jones filed by the Public Defender's Office. And I believe there were other letters here or there filed on your behalf from your counsel that I have reviewed as well. Ms. Rockow, have you received a copy of all of those documents, but in particular the pre-sentence investigation report?
I have.
And have you reviewed that report? And in your review, did you find any material facts or other information that needs to be corrected on the record?
No, Your Honor. Thank you.
Mr. Pollack, did you receive and review that report?
Yes, Your Honor.
Did you find any material facts or other information that needs to be stated on the record?
Just, I guess, a supplement. There was in the vocation and education and employment section some discussion of working at Gary's Cafe in Siren, but no dates provided. Mr. Jones advised that he worked there from February of 2024 until July of 2024. There was also a description of him working at a car dealership. He advised that was Luther Autos Hyundai in Bloomington from March 2023 until September 2023. Other than that, nothing else.
All right, thank you. Okay. Ms. Bauer, Victim Witness Coordinator, are we going to have any victim impact statement?
No, Your Honor.
And in my review of the case, I did not find any impact statement filed in this case. Is that correct?
Yes, Your Honor.
The only information that I have received from the victim would be the information contained in, I believe, in the complaint.
Yes, Your Honor.
Okay, all right. Ms. Rockow, argument and sentencing recommendation, please.
Thank you, Your Honor. The state has considered the material in the PSI, and of course, all of the facts and evidence in this case very carefully, and is joining the defense in a recommendation to the court for an imposed but stayed prison sentence. Specifically, the state is recommending that Mr. Jones be sentenced to an imposed but stayed sentence of, as to count 3, 2 years of initial confinement, 2 years of extended supervision, as to count 6, imposed and stayed 2 years initial confinement, 2 years extended supervision, and as to count 7, imposed and stayed 1.5 years initial confinement, 2 years extended supervision, all to run concurrent to each other, as this was one incident. I think that it's appropriate that they do run concurrently. The state recommends a period of 4 years of supervision. The state also recommends the court adopt the conditions that were outlined in the PSI recommendation for conditions of supervision. And as to the OWI, the state asked the court to adopt the joint recommendation for the 45 days of mandatory minimum confinement in jail. I believe that that's sufficient, as I stated, based upon the recommendation the state is making for the felony convictions. This, of course, we have to consider the Galleon factors, and we have to consider probation first. The facts of this case are very, very serious. There's no denying that. That is of utmost importance when the state makes a recommendation in a case such as this. And what will be best in terms of keeping the public safe. In reviewing Mr. Jones' history, he does not have a violent history. He has a history that looks like somebody who uses alcohol and makes bad choices when he uses alcohol. He is fairly young.
Here's where it gets interesting. The state is actually advocating against immediate prison time. Why? They're banking on rehabilitation over incarceration. In the justice system, that's like betting on a rookie over a sure thing, risky, but potentially
And I think, as evidenced by his criminal history and by what was outlined in the PSI and the facts of this case, he has a lot of rehabilitative needs. But the state disagrees that there is an obvious pattern of serious conduct that the defendant has engaged in, which was mentioned in the PSI. The only pattern that I see is that he has multiple OWI convictions. So that suggests a pattern of substance use. In considering probation first, I think that based on his record and based on his rehabilitative needs, the safest thing for the community is to indeed rehabilitate Mr. Jones within the community. I believe that probation can adequately supervise Mr. Jones within the community and do that in a way that will protect the community, that will protect the victim as well. I think that based on his record, based on his age, we're not at this stage yet where the state's position is he should go to prison for a lengthy period of time or at all. But certainly he has a significant amount of prison time in the imposed in state recommendation hanging over his head should he fail on probation. Probation will give him the tools that he needs to manage his sobriety and to manage any other issues that he has with criminogenic needs, such that he can maintain a life where he's contributing to the community. If the court sentences Mr. Jones to prison, I don't know what rehabilitative programming he'll engage in, but I think that it will impact his life in such a way that upon release, maybe he's not as engaged in or not as able to be engaged in work and community programming. If the court places him on supervision, he'll have those stability factors put in place right away. He'll have to engage in day-to-day real life.
What about 22 CF 012? And now there is a material fact that I have just discovered because DOC put it as 22 CF 212. Yes, it was dismissed and read into other cases, but there is a very similar fact pattern that was charged out by the district attorney's office. Very, very similar, where we had there were allegations of strangulation, suffocation, battery, disorderly conduct. Perhaps that's where we're getting the pattern from the DOC agent.
And I agree with Your Honor. I think that is the pattern that's the only pattern that they could be pointing to. My concern in using that as a basis for a pattern is that it was dismissed. It's a dismissed case. I don't know.
Then why was it charged by the district attorney's office? And we have the facts in that criminal complaint. Dismissed but read in charges. Are the court's able to view those and use those for sentencing purposes, not only for restitution, for sentencing purposes. And for whatever reason, back when he pled out in those cases, that was the deal then. It can't be overlooked.
It can't be overlooked. I agree with that, Your Honor. And I wasn't in this office in 2022, so I don't know. But I can say that it's not my practice to dismiss a case that serious unless there were some issues with the case itself and issues with proving that case. I don't know the facts and circumstances surrounding the dismissal of that case, but it looks to me like it was dismissed in favor of bail jumps. And so
bail jumps look better on a criminal record for a criminal than does strangulation, suffocation, perhaps. That's why you wheel and deal.
Of course.
Doesn't mean the facts didn't happen. That's why you wheel and deal.
Right.
The judge just peeled back the curtain on plea deals. Wheeling and dealing isn't just TV drama. It's how the sausage gets made. Charges vanish, others appear, all in the name of expediency. The moral justice is part courtroom, part chessboard.
And agreeing, to have something dismissed and read in also means that the state can't bring those charges again.
Except in another case like this.
So I don't know the particulars of that dismissal is what I'm saying, Your Honor. But the nature of how that case resolved with the felony bail jumps doesn't change my perspective in my sentencing recommendation. I want the court to know I did not overlook that case in making this recommendation.
You looked at the underlying facts in that case?
I did.
That it involved his previous girlfriend?
And Your Honor, what I can say is that, again, if this case weren't resolved in the manner that it was resolved.
Well, I'm going to say you don't know why it was resolved the way it was or how it was or what it is other than
Yeah.
wheeling and dealing and what looks better on a criminal record.
But I don't believe that the state would take that lightly and those charges lightly. And
You can't say that because you weren't in those shoes.
correct, yes. I don't know.
All right, you may continue with your argument.
Regardless of that case, I believe that this is an appropriate recommendation. We still have to consider probation first, and we still have to consider the rehabilitative needs of the defendant, his character, not just the severity of the facts in this case. I think that, again, his record more than anything reflects an issue with substance use. I think that's outlined in the PSI. There are some mental health struggles that are outlined in the PSI. His familial background, I think, tells us something about maybe how he got to be where he is today. Those are all things that I do believe probation can appropriately utilize the resources available to ensure that the community is protected and
Sure,
to
your phones are shut off.
ensure that the victim's protected. And again, I think most importantly, to restore this person so that he never does something like this again. And I think the question really is, how can we best do that? The state's position is that we can best do that through community supervision with this imposed and stayed prison sentence. He knows that he knows exactly what his sentence will look like should he violate any of the rules of his supervision. I think that jointly making this recommendation to the court instead of the defendant wanting to make a withheld sentence recommendation shows that he's serious about wanting to succeed on probation. While it can't be ignored that he did dispute many of the facts in the criminal complaint, as the PSI writer noted, but he did enter guilty pleas to 3 very serious felonies, arguably the most serious felonies that he'll have as convictions now on his record, though he does have those felony bail jumps. But this is a much different criminal history now that he has these 3 convictions. And he agreed to take responsibility for those things and enter guilty pleas to those 3 very serious charges. And again, he's agreeing that the sentence that we should recommend to the court jointly is an imposed and stayed prison sentence, which I think, again, shows that Mr. Jones is taking this very, very seriously. And I think that speaks to the fact that he is able to be rehabilitated. He needs, obviously, some support in doing that, but I don't see why probation wouldn't be able to do that. The bottom line, Your Honor, is I don't think that we're at a place with Mr. Jones at this moment where he needs to go to prison. Thank you.
Thank you, Mr. Pollock.
Thank you, Your Honor. I concur with the state. As Ms. Rockow stated, this is at this point a joint proposal before the court. I think I'm going to start by asking the court to adopt our sentence in the OWI matter. I think it's 24 CT 33 first. 45 days is the mandatory minimum penalty that the court can impose and must impose in a case like this. I think it's appropriate. Mr. Jones, as Ms. Rocco stated, did conclude a 1-year sentence in the county jail. I believe his final date on that sentence was February 24th of this year. At that point, he was remaining in custody simply on the revoked bond in 24 CF 170, which equates to 36 days in that case. So the 45 days, I think, are fresh days that must be served now. So there is an additional layer of protection to the public. Mr. Jones was coming into this hearing without knowing that the court expected a plea and sentencing in that case as well. And to his credit, he didn't balk at it. He went through the plea questionnaire. He entered the guilty plea, and he accepted a jail sentence despite knowing that the parties came into today asking the court to essentially let him out of jail today. So I think that speaks to the place that he is in now and how far that he has come. It's always strange, Your Honor, to be talking about serious violent type felonies for a 24-year-old man. And it's not something that I think any of us in this room take lightly. As Ms. Rocco stated, he did plead guilty to those. And as Your Honor stated earlier, that's different than felony bail jumps. Like, these are not dismissed and read in. These are convictions of record that will stand. I know that Mr. Jones may have disputed some of the facts or provided statements to the PSI writer that maybe tried to make himself look a little better than he was that night. I know in another case I spoke to Dr. Courtney Endress about a similar situation. It wasn't this case, but I mean, I think it's, to echo the doctor, it's something people do when they're confronted with things like this. They try and make it a little better for themselves. And I only bring that up because Mr. Jones has not backed away from this. He has remained in custody since, I believe, July 20th of 2024. He has not complained. He has taken his time and I think demonstrated an extraordinary growth. In our meetings, he's described a level of insight into his need for certainly AA and alcohol and other drug abuse assistance and treatment and programming.
But he says in the PSI, he doesn't believe he would benefit from additional treatment.
Your Honor, he may have said that. He has also confided in me that he has been doing Narcotics Anonymous and Alcoholics Anonymous while he's been in jail. I contacted Pastor Jack, who is the person who he told me was providing those services to him. Pastor Jack did provide confirmation of that to me, which I filed with the court this morning. Just reading briefly from that, I've met with Jacob weekly, and I've been involved with the jail AA and NA meetings on Monday and Thursday evenings at the Burnett County Jail. Mr. Jones engages during the meetings, and in one of my meetings, he seems to comprehend that the legal situation he finds himself in, what it's been grounded in, or the root cause of the behavior. So maybe he said that, maybe he even believed that at the time, and maybe he was only going to AA meetings for something to do or to try and make himself look better, but it sounds like he's engaging. Maybe he has had that breakthrough moment. I think he probably has. He confided in me this is the longest period of sobriety he's had since he began drinking. And I think that's very important, regardless of whether it was forced sobriety or not. It's been since July since he's been able to have any alcohol. He's also described his struggles with his mental health issues. He had been planning to go to a mental health